making recommendations on how to realize many of these benefits while ensuring that consumers' privacy is protected. Our counterparts around the world are asking the same question through similar efforts. The European Commission's recently released communication on a data-driven economy, the UK Information Commissioner Office's recent report on big data and data protection, the OECD's Global Forum on the Knowledge Economy, and Japan's review of its own data privacy law in light of big data challenges. These are just some examples of the common search by regulators, businesses, and others for answers about how to reconcile the furious pace of growth in big data analytics with more stable values such as privacy and fair treatment. I find it encouraging that all of us, with our diverse perspectives and legal systems, are affirming the relevance of fundamental privacy principles in the big data era and are focusing our attention not on whether, but on how the principles apply in our data-intensive world. So I'd like to focus on 3 specific challenges to building consumer trust and realizing big data's full social and economic potential. Let me begin with data security. We've heard a lot about it over the past 2 days, and we've also heard about it this morning. Data security has been a priority of the FTC for more than a decade, in part because we continue to see one massive data breach after another, putting consumers' identities and financial interests at risk. Data security is also an FTC priority because, quite simply, there is no privacy without data security. In recent years, we've made it clear that data breaches involving financial information, as well as unexpected revelations about our health, our families, and our location, or our activities in our homes can cause substantial harm to consumers. And now we're starting to discover that vulnerabilities in connected devices can also reveal highly sensitive information. This was precisely the issue in the FTC's first enforcement action concerning the Internet of Things, which involved feeds from Internet-connected home video cameras that were hijacked and posted in public Internet sites. Looking more broadly, a recent study by Hewlett-Packard found that 90% of connected devices are collecting personal information, and 70% of them are transmitting this data without encryption. I personally believe that those numbers are frightening. As more devices become connected to the Internet, the potential grows for more information about the most intimate details of our lives to slip into the wrong hands and to leave other consumer devices and accounts vulnerable unless appropriate security safeguards are put into place. Improving security of data that is personally identifiable or linkable to individuals is a must. While some are enthusiastic about indiscriminately collecting data now and sorting it out later, I see big security risks in this approach. To reduce these risks, companies should minimize what they collect and keep, and wherever possible, they should robustly de-identify this data and promise not to re-identify it. A second challenge to consumer trust comes from the collection and use of sensitive personal information. Today I'm going to focus on health information because it presents both some of the greatest opportunities and some of the greatest risks. Some of the most exciting prospects for society-changing innovations come from wearable devices and mobile apps that encourage consumers to collect and store their own health data. Yet much of this information, some of it highly sensitive, falls outside the boundaries of current U.S. law. Companies should give consumers greater control over collection and use of sensitive data like health information. Meaningful individual control is a much broader concept than simply permitting or refusing information collection at one point in time. Instead, companies should develop intuitive and immersive consumer dashboards, apps, and other tools that will engage and at the same time inform consumers about how their sensitive health information is being collected and used. And to the extent that this sensitive information winds up in data broker profiles, data brokers must similarly empower consumers with an easy-to-use portal that will give individuals the ability to keep aspects of their private lives away from big data-driven marketing. The third challenge to consumer trust that I want to highlight comes from the possibility of unfair or unethical treatment of individuals through increasingly powerful analytics tools. This is a challenge that all companies need to take seriously. Some of the findings of the FTC's groundbreaking study on data brokers, as Chairwoman Ramirez mentioned this morning, we released it earlier this year. This report raised some of these very issues. We found that profiles that these companies create about individuals, which may contain thousands of data points, will sometimes separate consumers according to race, ethnicity, family status, and other characteristics that companies are not allowed to consider for purposes such as housing, credit, employment, and medical care. In the marketing context that these profiles are intended to serve, merely collecting such information might not present a legal problem under current U.S. law. Indeed, these and other big data tools have the potential to promote economic inclusion. For example, big data-driven marketing can make underserved consumers aware of opportunities for credit and other services within their reach. But there is also a clear potential for use of this information to be harmful and discriminatory and to destroy consumer trust. The same data that allows banks to reach traditionally unbanked, financially vulnerable populations could just as easily be used to target them with advertisements for high-interest payday loans and other inappropriate products. And as companies begin scrutinizing their own data, they also need to be on the lookout for how data can lead them into making distinctions that are ethically, if not legally, questionable. For example, what if a company analyzing its own data in an effort to identify good versus troublesome customers ends up tracking individuals along racial or ethnic lines? A recent Harvard Business Review article argues that this kind of result isn't just possible, but it is inevitable. And all companies should think carefully about where value-added personalization and segmentation ends and harmful discrimination begins. Much of the challenge in ethical data practices lies behind the scenes, out of consumers' view. Therefore, more of the burden is on companies to ensure that their collection and use practices are consistent with a trusted relationship. I encourage companies to think about this entire project the way engineers think about designing automobiles. While we want to give consumers better control and transparency tools that they can easily access on their dashboards, we also must ensure that companies build better protections under the hood to ensure ethical treatment of consumers. Data brokers can take a strong proactive step right now by assessing the potential impact of their products that profile consumers by race, ethnicity, or other sensitive classifications, or that are proxies for such sensitive classifications. And companies that are beginning to dive into their own data should deploy greater resources and imagination to designing intuitive portals, dashboards, and other interfaces for consumers to control their privacy and security. Companies could make ethics reviews part of their big data analytics business practices, perhaps by creating consumer subject review boards to identify and reduce consumer risks. And whether or not companies go to this level of formality, every one of them should be asking whether their analysis of consumer data is taking them into questionable territory. The fundamental principles around privacy that many of us hold and enforce have proven over years and decades that they are durable and capture important attributes of individual freedom and autonomy. The rise of big data is only the most recent challenge to these principles. Many of us here today have concluded that traditional privacy principles can not only coexist with big data, but also will improve big data's chances for success. For those of us who care deeply about privacy, affirming these principles will not be enough. We will need to continue to examine specific big data challenges like data security, sensitive information, and discrimination, and get serious about how to apply these principles in our data-driven economy. Thank you very much.
The title of this session sounds like a state of near paradise. Privacy unlimited, no bounds, at least no territorial limits. I would say very fitting for a tropical paradise like Mauritius, with plenty of space around in the seemingly endless ocean. Indeed, one world, one privacy, a dream come true. At the same time, is it feasible? Is it feasible knowing, on the one hand, how borderless internet technology is developing, and on the other hand, how important national jurisdictions, and with that, national borders, territorial limits, are in reality, and certainly in lawmaking and law enforcement. Now, there is a real dilemma here, because the internet is developing more and more global, and as it penetrates our lives, it is also becoming more local. Global internet and its global impact of the internet services pose challenges of compliance with local and national law in relevant jurisdictions, but also, from the other end, a challenge of sovereign jurisdictions to leave their mark on what is penetrating in their world. The global impact of the internet often leads also to import or even imposition of foreign rules, foreign assumptions, foreign customs, foreign practices of other jurisdictions, with possible disconnects or even dysfunctionalities. Let me give you just an example. That is privacy policies. Invented as a concept and as a practice in the 90s in the United States, virtually in the absence of a legal framework, but providing via notice and consent assumptions the link to an enforcement framework for fair and lawful business. But that approach, as we all know, is far from perfect. It's referred to as very imperfect, in fact. But privacy policies in other jurisdictions do not necessarily have any of the same consequences. In fact,